Welcome to the Legal Aid Foundation of Los Angeles volunteer training for COVID-19 notification and landlord harassment. So our pro bono clinic will cover Know Your Rights regarding illegal lockouts, COVID-19 non-payment notification letters, and anti-harassment tenant protection in the city of Los Angeles. Know Your Rights. So under the Know Your Rights, we will cover the right to notice and unlawful detainer proceeding, protecting yourself against police lockouts, how to handle self-help lockouts, which is referring to when a landlord takes evicting a tenant into their own hands, and what are the remedies for tenants. Right to notice and unlawful detainer proceedings. So a tenant is almost always entitled to some form of eviction notice before they can be legally evicted from their residence. A notice can be a 3-day notice to pay rent or quit, or a 10-day notice, a 60-day notice, and so on. And these notices can be issued for different reasons, such as non-payment of rent, a tenant breaches the lease, or creates a nuisance at the property. And there are other reasons as well. Once the notice has expired, the next step for the landlord would be to file an unlawful detainer proceeding. And if this happens, the tenant is entitled to have their day in court as long as they file an answer to the unlawful detainer. Service of a notice is a prerequisite to filing the court action. The unlawful detainer process. An unlawful detainer or eviction lawsuit must go through all the steps of an ordinary lawsuit, a bit on an accelerated timeline. Most importantly, you must be served with a summons and complaint, which gives the tenant an opportunity to file an answer. The tenant only gets 5 days from receiving the summons and complaint to file an answer. If the tenant files timely, then the case will proceed to trial. This process could take several weeks. If an adverse judgment is entered against the tenant, the court will issue a writ of possession, which authorizes the sheriff to post a 5-day notice to vacate. But due to COVID-19 pandemic, the courts have effectively suspended most unlawful detainer proceedings, which means new cases can be filed, but the summons, the document that starts the case, can only be issued if there's a health and safety issue that makes the eviction needed to move forward because of the emergency. Next, we will be talking about how a tenant can protect themselves against police lockouts. The only way a tenant may be evicted is if the sheriff posts a 5-day notice to vacate on the door. There's a picture attached here. So the notice to vacate is a white piece of paper with red writing. The notice to vacate will tell the tenant when is their last day they could be there. If they're still there past that date, the sheriffs may come and remove them from the property. But you only received a notice to vacate if you did not file an answer to the eviction lawsuit, you missed your trial date, or you did not move out on the date that you agreed to in court. And lastly is if you lost the case before the judge. Sometimes landlords make claims that the tenant's a trespasser, so sometimes a landlord will call the sheriff's or local police department and claim that the tenant is a trespasser, demanding that the tenant be removed from the premises. So if this happens and the police or sheriff come to the tenant's unit, the tenant can do these 4 things. Number 1 is remind them that an eviction is a civil matter and not a criminal matter. And they could ask politely to see a writ of possession and ask them why they have not been served a notice to vacate. 2, remind them that evictions must be carried out by the sheriff if the local police department come out. 3, the tenant must be prepared to have some proof of tenancy, such as a signed copy of a lease or rent receipts. But but proof of address could work, such as driver's license or school IDs. The more official, the better. And 4, if the officers that come do not help the tenant could ask to speak with the watch commander or police supervisor. Next topic we will cover is how a tenant can protect himself against self-help lockouts, which is when a landlord takes evicting a tenant into their own hands. As explained earlier, a landlord cannot lock out a tenant unless the sheriff has posted a 5-day notice to vacate with an authorization from the court. And during the COVID-19 emergency, LA County sheriffs are not enforcing lockouts. A landlord who illegally locks out a tenant may be liable for severe civil penalties, which are detailed in the next slide, and may even be guilty of a misdemeanor under California Penal Code Section 418.00. So if the tenant's landlord changes the locks, the tenant could call the police and ask to speak with the watch commander. Again, the tenant wants to have proof of tenancy, like that, such as a lease agreement or other proof of address. And the tenant also wants to explain to the police that the landlord has illegally changed the locks and ask for assistance to re-enter the premises. The police may be persuaded to assist, but and most importantly, the tenant must not break the locks and re-enter themselves. Some things to consider when speaking with the police are Governor Newsom's executive order of March 19, which requires all individuals living in the state of California to stay home or at their place of residence, except as needed to maintain continuity of operations of the federal critical infrastructure sectors. And the LA County Board of Supervisors has prohibited evictions through May 31st of this year, stating that it is essential to avoid unnecessary housing displacement, protect this county's affordable housing stock, and prevent housed individuals from falling into homelessness. Finally, due to COVID-19, court closures, an illegally locked out tenant does not have any redress in civil court. A suit for damages can be brought later, but a tenant cannot currently access the court to enforce her right to possession. It will be in the discretion of police whether they assist the tenant. If the person you are speaking with at the station is not helpful, the tenant can always ask to speak with a police supervisor or watch commander, or at the very least make a police report to document or prove what and when the lockout happened. We will be discussing civil remedies next. These are the applicable laws. So California Civil Code Section 789.3 subsection B states that it's illegal to block access to the property by changing locks or otherwise without a court order, remove outside doors or windows from the unit, remove personal property or furnishing without the consent of the tenant, terminate or interrupt utility services. California Civil Code Section 1940.2 states that it's illegal to steal, extort, or menace to drive the tenant to vacate the dwelling, or threaten to disclose the tenant's immigration status to drive the tenant to make the tenant vacate the dwelling. And California Penal Code Section 418 states that every person using or procuring or encouraging or assisting another to use any force of violence in entering upon or detaining any lands or other possessions of another, except in the cases and in the manner allowed by law, is guilty of misdemeanor. And these applicable laws provide remedies to the tenants. So Civil Code Section 789.3b states that a tenant may recover statutory damages of $100 per day or part of a day that the landlord is in violation. Also, attorney fees. California Civil Code Section 1940.2 states that civil penalties of up to $2,000 for each separate violation. And California Penal Code Section 418 allows for fines not to exceed $1,000 or up to 1 year in county jail. How can a tenant enforce their rights? Tenant can do 4 things. They could send a letter to their landlord citing the relevant law, demanding that the landlord take action to correct whatever they did. This could be either by giving the tenant a new key to the changed locks, replacing the doors or windows that they took down, or by turning the utilities back on. And the tenant should also send a letter to the landlord certified by certified mail or an email. 2, they could call the police and file a police report. 3, they could report to an appropriate governmental agency. And then, in the case of a utility shut off, they can contact the utility company directly. But the most important thing is that the tenant should document everything, because the final mechanism for the tenant would be to sue their landlord either in small claims court or civil court. Small claims would be anything under $10,000. Civil court would be anything greater than $10,000. Due to COVID-19 emergency measures, though, filing it will be indeterminate. So we're not sure when the tenant would be able to file in court. And thus, it's important to document everything. And it will also help the tenant bring evidence to their case. Now we will look at the COVID-19 non-payment notifications. So Governor Newsom on March 27, he ordered a moratorium on evictions. So the governor's order may delay an eviction by extending the time to file a response to an eviction action for 60 days if the tenant takes the following steps. If the eviction is based on non-payment of rent, if the tenant cannot pay rent because of COVID-19 related reasons, if the tenant notifies the landlord within 7 days of rent being due, and if the tenant provides documentation of the loss of income due to COVID-19. This order cannot be used as a defense to an eviction case against the tenant. It only delays the filing for the response, for the answer for the tenant to an eviction case by 60 days. Besides state protections, tenants also have local protections throughout LA County and other counties throughout the state as well. So local cities and counties have passed their own tenant protections. LA County has passed eviction protection for tenants of unincorporated area of Los Angeles County and for tenants who reside in cities where the city has not passed their own tenant protections. The city of LA has also passed protections, but their protections only apply for tenants who live within the city limits. So what measures has LA County taken? LA County has taken the following steps for tenants who cannot pay their rent due to COVID-19. So starting March 4th to June 30th, tenants who cannot pay their rent because of financial impacts related to COVID-19 or who received a non-full eviction notice are protected from a 3-day notice or eviction if they give their landlord a written notice within 7 days of the rent being due and save the documentation. And landlords can collect rent after 1 year once the emergency expires. So if the tenant gets an eviction for rent owed during this time, the ordinance can be raised as an affirmative defense. For tenants who receive Section 8 or are on HUD housing, what they can do is they could update their case manager of loss of income if they're experiencing a financial impact related due to COVID-19. And once they've gained employment, they can update their income to reflect their current values. And they can also reach out to their case manager and housing authorities to give notification of changes of income. There's also federal protections, which is the CARES Act. So the CARES Act was signed by the President on March 27. So the CARES Act provides tenant protections for those tenants living in buildings or units that are covered by federal subsidies, such as Section A or project-based housing. And this means that landlords cannot file evictions during the 120-day moratorium period. And only after the moratorium period ends, a landlord can serve a 30-day notice. But this 30-day notice cannot be served during the moratorium period. Also, there can be no late fees, penalties, or other charges related to non-payment of rent. The tenant should ask the landlord for this information. If the landlord doesn't know, then the mortgage servicer is required to provide it. Transitioning, we will talk about the new anti-harassment tenant protections in the city of Los Angeles. So what are these new protections? Starting May 12th, 2020, and for 12 months after the emergency is ended, a landlord may not endeavor to evict a tenant due to COVID-19 financial impact. In addition, a landlord may not endeavor to evict a tenant based on no-fault basis, or for unauthorized pets, guests, or for creating nuisance related to COVID-19. Also, no owner shall charge interest or late fees on rent not paid during this time. No LS Act evictions until 60 days after the local emergency ends. This applies from beginning of local emergency to non-payment and no-fault evictions, but remedies discussed in the next slide begin May 12, 2020. Also, tenants may use this law as an affirmative defense during an eviction proceeding. And lastly, a landlord must provide notice within 15 days of the effective date and each time they serve any eviction notice during the local emergency and for 12 months after. Under this new ordinance, endeavor to evict means two things. The owner lacks a good faith basis to believe protections apply, and two, serves or provides in any way to the tenant an eviction notice. If a landlord violates this provision, a tenant may sue for an injunctive relief, a civil penalty of up to $10,000 depending on the severity of the violation. The court may award additional civil penalties of $5,000 if a tenant is over 65 or disabled. The court may also award reasonable attorney fees to the prevailing party. A tenant must first give the landlord written notice of the violation and 15 days to cure the violation before the tenant can sue the landlord. The violations are also affirmative defenses and an unlawful detainer. So what is this clinic about? So in this clinic, we will be assisting tenants in drafting the following pro per notifications or letters, non-payment of rent letters. So we will go to norent.org and to draft the tenant's letter. We will also be drafting letters when the landlord has been harassing them or has locked them out of their unit, or we will be drafting letters concerning Los Angeles City notification of harassment, LAMC 49.99. The to-do list includes one sample templates will be available to you. Once they're completed, a LANDLORD member will review them to make sure that they're fine. 2, litigants will be asked to complete the mailing of the letter to their own landlords and to make copies for their own personal records. 3, please ensure that the litigant receives the email with the letter attachment. And 4, remind the litigant to mail the letter to their landlord as soon as possible. If you have any questions, you could feel free to contact us. You can contact me at lmendez@lawful.org or Manuel Villagomez at mvillagomez@lawful.org, or you could contact Jeffrey Uno at jmuno@lawful.org.